Hello, I'm Catherine Mitchell. I'm the Director of Mitchell Law, and I'd like to welcome you to the Mitchell Law Tea Break. This is the third in our occasional series of short videos discussing employment law topics for HR professionals, and I hope you'll enjoy it. Today I'm discussing stress at work, and this is my colleague, our in-house barrister, Joanne Sefton. Hello, Joanne.
Hello, Catherine. I think this is one we could talk about for an hour, couldn't we?
I think we could talk about it for much longer. It's certainly one of those topics that clients wrestle with regardless of the sector they're in, isn't it? And I suppose that's because in part there's not one easy answer. In fact, there isn't one answer at all because each case is so different, and the robust approach that might get you a really good result in one case might create problems in another.
Yeah, I mean, I think it's worth narrowing down the sort of case that we're talking about for this broadcast. We're not talking about employees who have clear, potentially serious pre-existing diagnoses of mental health problems. We're talking about the sort of employee who turns up, or rather doesn't turn up, produces a sick note saying 2 weeks off, stress at work. What do you do about it?
I think that's right, and it's really important to start there. Everybody's very busy in an HR department. It's quite easy to get one of these sorts of sick notes in, keep your fingers crossed, let it drift perhaps for a few weeks and hope that the employee comes back and everything gets back to normal. But generally, in my experience, if a problem has been identified at work, then staying away from work is rarely going to resolve it.
Yes, I think the first thing we'd always advise clients is to check their absence management policies, make sure that they're robust, which they often are on paper, but then make sure that they use them and that these absences are picked up on and addressed by line management or by HR if necessary, sooner rather than later.
I think that's right, and for me there's also a big question about how much contractual sick pay an organisation offers, and there can be a tendency for these things to come to a head only when the sick pay runs out. And if that's after 6 weeks or 3 months, then you're in a much better position than if the employee has been at home for a year.
That's definitely my experience too.
And I've worked with quite a number of organisations, including unionised ones, where reducing contractual sick pay entitlement has been largely motivated by these sorts of stress at work cases. And of course, we're not talking about the cases where someone ends up in hospital or has a personal tragedy, where the organisation can always choose to extend paid time off as a matter of discretion in the right cases. But where it's seen as a right, then in my view, sometimes it can become an obstacle to managing employee relations.
So hint number one is to sort out your sick pay policy. I'd also add to that to sort out your occupational health provider, and there's a massive difference in the approach of different providers on the market. It's worth being aware of that and trying some out. Sometimes the most important thing is just getting someone who's local and getting someone who can see someone quickly. But at other times you might need more of a specialist in a particular area, or someone who's less likely to accept everything the employee says completely at face value and is more prepared to slightly challenge that and to put forward their own clinical assessments, even if that isn't in line with what the employee wants to hear.
Yeah, I think there's a lot of value to be had in shopping around for that service. And related to that, I'd also give some consideration to how you deal with medical information received in from GPs.
And what do you mean by that exactly?
Well, I always remind clients that GP advice is advisory and it's not binding on an employer. So an employer is entitled to take a view on what weight to place on a sick note coming in. Particularly, that's the case, I think, where very little might have been provided by way of detail from the doctor or the employee themselves about the condition.
Yeah, you do see that, and of course the doctor's professional obligation is to their own patients, not to the business. They may well see it as being part of that role to act as an advocate for the patient, and even aside from that, they're very likely just to be really, really busy, so they don't necessarily have the time to challenge or to go behind what they're being told.
Yeah, I think that's very often the case, and some employers might feel that it's not too difficult for employees to get themselves signed off on grounds of stress for a month if they want to.
I think that's right. I think the problem with that is that when it is a problem at work, as we said earlier, it really just goes away within that time frame of the period that they have off, does it?
No, and I think as all our HR clients know, there's lots of evidence around the fact that the longer someone stays out of the workplace, the less likely they are to get back.
So would your advice tend to be that people can be quite assertive in pushing to go on with procedures, in arranging meetings, in trying to address the obstacles to a return to work, and really trying to make the running on making that happen?
Yeah, I think so, and of course it depends on the individual circumstances in that case, but I would say being appropriately assertive. Something I would observe a lot is that I see employees complaining or threatening that their employer is harassing them by trying to maintain communication when they're off sick. But it's right to say that it's very rare that these sorts of cases actually make it to the tribunal, and even when they do, very few are upheld. And of course, you can do a lot to make it as easy as possible for the employee to engage in the communication. So looking at neutral venues or being flexible about who can accompany them to a meeting, changes like that can help, because it's fundamentally in everybody's interest to make sure these meetings happen, that everybody does know exactly what the background is.
Yeah, and one of the scenarios where this kind of situation can arise is where there's a separate procedure going on. So if someone's under investigation, perhaps a disciplinary thing or a performance thing, and they go off sick at that point. And I think we would stress the importance of continuing with that procedure.
I think so, and we always work hard with clients to make sure that those sorts of processes aren't derailed by somebody who goes off sick on the grounds of stress.
I think so, and again, you say on the grounds of stress, and it is important to make that differentiation. There's some really helpful authority around the fact that stress itself isn't an illness. It's unlikely without more to be a disability, and you probably want to take a more robust approach to that sort of case, obviously, than a case with a different diagnosis where you would want to tread much more cautiously.
I agree, yeah, and that's the reason why one of my other top tips would be to be confident about asking questions, because it is in everyone's interest to act with the best possible information about the medical condition, including the prognosis. And I think you shouldn't be scared to push appropriately for the employee's cooperation in getting that, and that's something else we can help with.
Yeah, we do. I think a final area that's worth touching on is workplace mediation, and ultimately the possibility of an agreed termination. And stress cases are not always, but often associated with relationship difficulties in the workplace, and that perhaps might be a clash with one particular manager, or it might be a more widespread thing. Yeah,
I think that's right, and it's true that workplace mediation can be a great help in those sorts of cases, but sadly it doesn't always work.
Yeah, I think my completely unscientific observation would probably be that it can work where you have a one-off scenario that's come about. You do get cases where employees seem to have a track record of repeat fallings out with different managers or different colleagues, and I think in those cases mediation might just offer a sticking plaster, but then a year later, 18 months later, you find yourself in the same situation.
Yeah, I've seen that, and I think you get the opposite story where it's the manager who's the common factor in the failed relationships, and then potentially you're looking at whether that person is right in that position. Yeah, definitely. I also suggest, if you're using the mediation route, to have a look at different mediators, do your research and get some references about what they were like. It's the same story as with the occupational health providers, really. Different people are better for different situations, and there's some value in doing your research before you go for someone. Yeah, I agree. I think just touching on settlement, very often that can be the best way to bring the situation to a close if you do have those sorts of intractable relationship problems or a long-term stress absence. Again, obviously it depends on individual circumstances and the wider picture for that employer. Yeah, and I think the one thing to really be aware of there is if you've got the open process going, whether that's an absent management process or a disciplinary process, and then you start having settlement negotiations, is don't forget about the open process. Make sure that you keep pushing that forward and ticking that box. Otherwise, if you let things drift, you can face difficulties either with having to go back and start from square one, or potentially if you get in front of a tribunal and there's holes in the case that you're putting forward. It's that sort of drift that we always try really hard to avoid if we're helping with the case, isn't it? Doesn't happen if we're involved, does it? It doesn't. So thank you very much for joining us for the Mitchell Law Tea Break on managing stress absence. We hope you've enjoyed it and found it helpful. Please join us again for the next one. Thank you.